This case is one of those courtroom stories that leaves everybody uncomfortable because no matter how you look at it, somebody is gone forever and the people left behind are still trying to figure out whether this was a tragic accident, reckless behavior, or something that should never have happened in the first place. Today's hearing isn't actually about guilt or innocence anymore. That part was already decided years ago. What we're watching now is a fight over whether a woman convicted in a deadly shooting deserves to end her probation early after what her attorney says has been near-perfect compliance with every condition the court gave her. But here's where this gets complicated fast. The defense paints this as two young people behaving recklessly around firearms, a split-second mistake, and a tragedy that changed lives forever. The prosecution, meanwhile, keeps bringing the conversation back to one unavoidable fact. Someone picked up a gun, pointed it, and fired. And the judge? You can already tell this is a courtroom where nobody is going to rewrite history just because time has passed. Pay close attention to how both sides argue the facts here, because the details matter. Was the gun unloaded? Was the clip removed? Did she believe the weapon couldn't fire? Was this panic, recklessness, or criminal negligence? Even years later, the court is still debating exactly what happened in that room. And what makes this hearing fascinating is that the judge remembers nearly every detail from the original trial. That's never a good sign if you're hoping for an easy early release from probation. Also watch how the defense tries to frame rehabilitation. They're not arguing she's innocent anymore. Instead, they're arguing she accepted responsibility, cooperated with police, completed every probation requirement, stayed employed, raised her children, and rebuilt her life. The question becomes, how much punishment is enough when a death was caused by recklessness rather than intent? And that's the emotional tension hanging over this entire hearing. The court acknowledges she didn't mean to kill him, but at the same time, a young man lost his life. So now the judge has to balance accountability, rehabilitation, public safety, and basic fairness all at once. By the end of this hearing, we're going to see whether the court believes good behavior is enough to shorten a sentence tied to a fatal shooting, or whether some consequences simply require more time no matter how remorseful someone appears afterward.
I'm not trying to make you feel any worse than you already feel. But honestly, they're dead because you picked up a gun. Whether you knew it was loaded or not, you picked it up, you pointed at him. All right. The defense has filed a motion for early termination. State, have you had a chance to review the defense's motion?
Yes, Your Honor.
Right. State, are you in objection to the motion?
Yes, Your Honor, we do object to it.
All right. Defense, do you have any witnesses?
We may have Miss Jenna Castillo. Her father is here in court.
If you want to call witnesses, you can choose to call witnesses.
Well, Judge, at this particular point, I would just move forward with the evidence that I believe that we have per the report from the probation officer, and then just go that route. If the court deems it necessary for us to have witnesses, because basically we will say what the witnesses likely will say, maybe.
All right. Does your client want to say anything?
I'm sure at some point she might want to say something, Judge. I'm assuming you would like to hear from her in situations.
Well, I'm here to listen to whatever evidence anyone wants to present.
Exactly. So do you want us to start now?
Yes.
Judge, thank you so much for granting us this opportunity to come before the court today to hear our motion. As the court may recall, this trial, it was a very intense trial.
I recall the facts.
I know you recall the
Mine's
facts.
a steel trap. I can tell you the entire case.
I know. And Judge, you and I, we've talked, not in terms of this case, but I know sometimes you think I talked a little more than maybe is necessary.
No, I did not. But it's okay if people want to be Charles Dickens and get paid by the word. I'm fine with that.
So I don't want to do that.
No, you can. I'm serious.
Okay. All right. So as the court recalls, again, this, was a very intense trial. And I'll just basically, I know you know the facts, but just, to talk about the facts again on behalf of Ms. Castillo. This was an
playing with guns.
Well, Judge, let me say it. They had been together the entire day, not playing with guns. going to the store, doing just different types of things. Her boyfriend was playing with the gun. And in fact, a few days earlier, I think he had played with the gun. Had nothing to do with Miss Castillo. On the day of this event, the boyfriend had a gun in his hand. Miss Castillo was attempting to leave. They wanted to go. They were planning on going out. He took the gun and he was playing with the gun that had a beam of light on it, and he was pointing it at her. His cousin comes into the room, says to Miss Castillo, "You're going to let him do you like that?" Takes a clip out of his gun. His cousin's 18 years old, takes a clip out of his gun, hands it to the evidence is either he hands it to Miss Castillo or he throws it on the bed. There was some contradiction as to how that happened. But at some point, Miss Castillo gets the gun, the clip is out of the gun. She thinks the gun was unloaded. Next thing you know, her boyfriend.
This is one of the most important moments in the hearing because you can immediately see a subtle tug of war happening between the defense attorney and the judge over the facts of the original case. And in court, that matters more than people realize. The defense is trying to reinforce the idea that the gun appeared unloaded because the magazine had supposedly been removed. That detail supports their entire argument that this shooting was reckless and tragic, but not intentional. Meanwhile, the judge remembers the case differently, and judges remembering details differently years later can seriously affect how they view a request like this. Notice something else too. The judge isn't emotional here. He's analytical. He's reconstructing the timeline from memory, almost like replaying evidence in his head. That tells you this case clearly stuck with him. And honestly, cases involving young people, firearms, and accidental deaths tend to do that. The defense keeps emphasizing confusion, panic, and immaturity, but the court keeps returning to responsibility. Because regardless of whether the clip was removed, one universal firearm rule remains. Never point a gun at someone unless you are prepared for the consequences. And this is where viewers are probably split. Some people hear this story and think, this was a horrible accident between two immature young adults. Others hear the same facts and think, a preventable death is still a preventable death. Let me know in the comments where you stand, because this hearing is really testing the line between rehabilitation and accountability.
And the shot.
All right, so let me just say this. The way I remember
Yes.
the trial is that she was coming out of the shower. She was in a towel. The boyfriend had a gun. His mother had bought him as a Christmas present laser pointers that had the Christmas colors. He pointed his gun at her. It had a green laser on it. His brother tells her, "Hey, are you going to let him do that to you?" And she picks up a gun off the dresser. That's the way I remember the facts. There is nothing about a clip being taken out of the gun. She sees a clip out of the gun. That's the way I remember the trial.
Okay, Judge, and I respectfully want to correct you with that, and I'm pretty sure of that. The argument was that the clip was taken out of the gun. Even in closing argument, I argued that as one of the points as to why it is she did not believe that the gun could fire, because she did not believe that there were actually bullets in the gun because the clip was out of the gun. I probably spent 5 to 10 minutes arguing that point alone. So the clip was out of the gun, which is what we presented as the evidence in the case. And even after the trial, when talking to the jury, a lot of them understood that they believed that the clip was out of the gun. So that wasn't what the case hinged upon, but we did present evidence at the time that the clip was out of the gun. And Your Honor, you are correct that she was coming out of the shower. She did have a towel on because she was planning on leaving. They were planning on going out, but the boyfriend, again, was playing with the gun. So this is a totally different gun. I understand that the state tried to put on evidence, or they put on some evidence, I believe, that the gun had been on the dresser at some point, because and you called him the brother, I think he was a cousin, he was stating that he never brought the gun into the room. But we put on evidence that he did, in fact, bring the gun into the room. Talking to the jury after trial, they believe that too. Now, obviously, the jury found her guilty. We understand that. I did talk with the jury after the trial. The jury placed her on probation, did not sentence her to prison. And the overall thing of it for them was that, obviously, if you have a gun, you shouldn't play with a gun. That's just, I mean, and we all understand that. She understands that here today. Nobody's fighting that particular point that you should not play with a gun. But it's important for us to state that the person who was shot and killed, unfortunately, was pointing a gun at her and had been pointing a gun at her. And it wasn't until the cousin introduced his gun and gave it to her or presented it to her, put it there in front of her and told her, are you gonna let him do you like that? And she picked up the gun. There's no doubt whatsoever that she intentionally took the gun in her hand. So we're not trying to say that somehow the gun fell into her hand and she had, nothing else to do but to pick it up and shoot her boyfriend. She was not attempting to shoot him. In fact, after he was shot, she immediately rushed over to help him. She did everything she possibly could do to try to save his life. She was hysterical. When the police arrived, the deceased mother tried to say that Miss Castillo had not, in fact, shot her son, that some robbers came in the house and had shot the son. And Miss Castillo said to the police at that point, no, that's not true. I shot him. And so
This section is incredibly important for the defense because they're trying to establish something courts often weigh heavily during probation reviews: honesty and post-crime behavior. According to the attorney, when other people were allegedly trying to tell police that robbers committed the shooting, she immediately admitted what happened. That's a major point in her favor because judges tend to look differently at defendants who cooperate versus defendants who lie, flee, or obstruct investigators. But there's another layer here that makes this emotionally difficult. You can hear the defense repeatedly describing her hysteria, her grief, and the fact that she tried to help him after the shooting. They're essentially arguing this punishment has already followed her emotionally every single day since the incident occurred. In other words, they want the court to see her not as a violent criminal, but as someone who made one catastrophic mistake and has been carrying the psychological consequences ever since. Still, prosecutors and judges also think about deterrence. If courts become too lenient in cases involving reckless firearm handling that results in death, what message does that send publicly? That's why manslaughter cases are so difficult. Nobody is saying she planned a murder, but criminal negligence involving deadly weapons can still permanently destroy lives. And honestly, this hearing is a reminder of how quickly playing around with firearms can turn into irreversible tragedy within seconds.
So the police did not have to worry about trying to investigate whether or not robbers came in the house and shot the young man, which is the story that the family was presenting to tell the police at that time. She took full responsibility at that particular time for being the one that in fact had shot him. It was not presented as a murder case. It was presented as a manslaughter case because of the reckless nature of this particular incident. After the young man was shot, again, we say that Miss Castillo was hysterical. If you recall, she was sitting in the yard. She kept calling his name. When she went to the police station, she told the truth. She was forthcoming. She's always been forthcoming. The jury did, in fact, again, find her guilty of the offense. They found her guilty of the offense. But again, I talked with a lot of jurors, which is my normal course after these trials. And many of them believe that this was a very unfortunate incident, that she had no intention of shooting him, that it was an accident. However, they felt because there was a gun involved and there was some degree of playing with the gun on her part, that she should have anticipated that something like this should happen. But they also felt it necessary that she be placed on probation. After the trial, the court, Your Honor, in talking with her, I remember or recall you intimating that you would be following this case very closely, making sure that she abided by the terms and conditions of her probation, and that if in fact there were any infractions, that could result in her going to prison. We told you at that time that we believed that she was a good young lady, that she would do the right thing, that we did not believe that there was going to be any issue with regard to that. And you intimated that, well, if not, the possibility always is that she might be early term. Of course, the court would not state at that particular point that that would be something that would happen, but it gave her something to strive for. It gave her something for which to have hope. And so she has complied with the terms and conditions of her probation. She is up to date on all monies. She's paid all monies. She's done all courses that have been presented for her to do, including a parenting class. She's done all of her community service hours, 200 hours of community service. She is gainfully employed. She's raising her now 2 children. She had a son at that particular time. Her son is a straight A student in school, well adjusted to school. She has done everything that this court has asked her to do. She is not putting this behind her because she loved the young man that was killed. That was her friend. And this has been devastating to her. And obviously, it's always devastating to the family. You can never get around that. And you would not try to get around that. But I believe that Ms. Castillo has presented herself well before this court. I don't think you've had any trouble out of her. And she's just tried to comply with everything she's supposed to do. I've kept in touch with her over the years and with her family over the years to see how she's been doing. Having another child, continuing to be employed, keeping up with her probation. I'll talk with her about it. And she says, yes, Mr. Marshall. Yes, Mr. Marshall. So I just think that she is a worthy candidate. She is a worthy candidate for early termination on this case. And I would ask that the court would consider terminating her probation.
All right. So the way the court remembers the facts of this case is, as I previously stated, and an expert was called to testify. And the questions that were being asked of the expert were whether or not dropping a gun, because that was part of the defense. The gun was dropped. The gun went off accidentally, and the gun hit at such an angle, a lucky angle, that killed the complainant. And then the expert testified, and I believe it was defense expert testified that no, this gun would not go off if dropped accidentally. And there may have been some closing argument about then maybe she didn't know the clip was loaded or not loaded. State?
After the state, if I may.
Sure.
For argument or about the facts, Judge, because you're the one with the facts.
No. I'll hear your argument.
Yes, Judge. At this point, a jury did, hear all the facts, and they heard them as you did, Judge, and they still returned a verdict of guilty. And as we know, they have the option of assessing as low as 2 years if they were going to give probation. The jury chose, after hearing all of the facts and hearing all of the argument, the jury chose to give her 10 years, which seems to be deserved for probation, Your Honor. It does seem like this was a probation-worthy case, but they still chose to assess the maximum amount of probation being 10 years. And we would just ask that the state follow that, and that the judge follow that, because then at the end of the day, a young man lost his life. And as we both know from other, expert testimony, just because there's not a clip doesn't mean that the gun's not loaded. And first rule of gun safety, you don't point a gun at somebody unless you intend to fire it.
And if I may, Your Honor, that's just not the facts of this particular case. I believe the fact in this case, which was undisputed, that she had never personally handled a gun before. Also, when talking about whether the gun fell to the ground or not, I don't believe our argument was that she dropped the gun. Our argument was that because of the type of gun it was a gun that had been known to have a quick trigger. And so questions were elicited as to whether or not, if the gun was dropped, so on and so forth, would it fire? And our expert, which we knew what he was already going to say, basically said with respect to that gun, no. But what we were really getting to was the nature of the quick trigger in this particular case, because there was some issue as to whether or not this gun fired with a quick trigger. And so when having the gun in her hand, is she intending on firing the weapon, shooting her boyfriend, so on and so forth? No to that. But we were, eliciting questions as to whether or not, or answers as to whether or not the gun had a quick trigger. And so our expert witness said he did not believe in his expert opinion that that particular weapon, although that style of weapon was known to have had a quick trigger. He didn't believe that that particular one did, because he was not able to test that gun until, I believe, the day of trial. I think the day he testified was the day that he was able to look at that gun on the stand, actually, is when he was able to do that. So with that having been said, again, the jury did find Ms. Castillo guilty. Again, I talked with the jurors after the trial. And in fact, I believe we even argued, or at least let them know that, and I think I even requested at some point that they give her the 10 years of probation, right? And with the idea that if she complied with probation, that she might be early termed. And I talked with some of the jurors about that after the trial, and they understood that if she was in compliance, that, the court had the discretion of early terminating her from probation. So I don't even think that all of the jurors, really thought it necessary that she do all of the 10 years. What they thought was really most important was, one, that she understands the nature of what had occurred in this particular case and how serious it was. Two, that she responds as one, not only with words coming before the court and saying that she's going to do the right thing and be the right kind of person, but that her actions would actually follow. And her actions have. She's done everything the court has asked her to do. She's paid everything. She's done all of her community service hours. She's done all of the classes. She has a very good rapport with her probation officer. I believe the probation officer, the one that, told her to come before the court and ask the court to terminate her early, if my memory serves me correct. So it's just one of those cases where, and I understand, I get it.
This is probably the strongest stretch of the defense's argument, because now they're no longer debating facts from years ago. They're focusing entirely on rehabilitation. Listen to everything they list off: completed community service, completed classes, paid all financial obligations, maintained employment, raised children, stayed compliant, built a positive relationship with probation officers, and reportedly caused zero problems while under supervision. From a probation standpoint, that is exactly what courts hope to see. But then the judge shifts the entire conversation with one brutal reality check. Somebody is dead. That changes everything. The court is basically saying, yes, you're doing well now, but the severity of the original harm still matters. And legally, judges have enormous discretion in these situations. Early termination isn't automatic just because someone follows the rules. Especially in a manslaughter case, judges often consider whether enough time has passed to reflect the seriousness of the loss involved. What's interesting here is that the judge even admits he might have handled the case differently had it originally come before him through a plea deal instead of a jury trial. That's a huge statement. He's essentially acknowledging that he viewed the case as reckless immaturity rather than intentional violence. But despite that sympathy, he still isn't willing to cut the probation short yet. That tells you how heavily the fatal outcome is weighing on this decision. And honestly, this raises a difficult question. If someone fully rehabilitates themselves after a deadly mistake, should the justice system prioritize punishment length or demonstrated change? There's no easy answer to that.
I understand it's a manslaughter case. Somebody lost their life. And you know what? You just got to do the 10 years. Well,
no, actually, counsel, and I believe afterwards, both you and the state's attorney came before the court after this was all over and asked the court, hey, if we would have came for you on an open plea, do you remember that conversation?
And I believe you said that you would have given her deferred adjudication.
No, what I said was that if you all had come to me on an open plea, that I would have given her deferred, because these were two young children playing around with guns. That's what happened. Two young children playing around with guns. And I said their parents were allowing them to play house and play around with guns. And I would have given her deferred adjudication. But where we are now is she hasn't even done 5 years on probation yet. And in the big scheme of things, somebody is dead. I understand that she loved him. I do remember the facts of the case. I remember her being on the sidewalk when the police came and she was telling them that she shot him. And the complainant's mother is saying she doesn't know what she's saying. She's in shock. Robbers came in. I remember that. So I want you to know that I remember all of this. I remember that you were very distraught because the person that you loved died, right? And I know you didn't mean to kill him. That's why it's a manslaughter case. And I know that part of the fault, and I don't like to pass blame around, but parents should not have allowed children to be playing with guns. And I remember listening to the testimony and thinking to myself, I didn't know laser pointers now come in Christmas colors, holiday colors. You know, why are people marketing holiday colors for people and especially children? But my problem with this case in granting you early term is you haven't even done 5 years yet. This is from 2020. You need to at least have done half the time. And I know you can come forward at a third of the time, but at the end of the day, someone's dead. And I'm not trying to make you feel any worse than you already feel. But honestly, they're dead because you picked up a gun. Whether you knew it was loaded or not, you picked it up, you pointed at him, and you fired. So you should at least serve half the term before you come to the court asking for early term. You understand?
Yes.
All right. So at that point, I will strongly consider your motion for early termination. But now you've just been on since 2020. And I know sometimes people rush through conditions that are given to them. And I appreciate that because I want you to do it. You appear to be on the right track. You're doing what you need to do. But a third of the time and somebody's dead is not enough in this case. You understand?
Yes, ma'am.
So come back when there's 5 years that have elapsed and the court will strongly consider your motion for early termination. Do you understand?
Yes.
All right. Thank you.
In the end, the judge denied the request for early termination, at least for now. And the reasoning was actually pretty clear. The court acknowledged her progress, acknowledged her compliance, acknowledged her remorse, and even acknowledged that this was not an intentional murder case. But the judge kept returning to the same unavoidable fact. A young man lost his life because a gun was picked up and fired during reckless behavior. What makes this hearing so compelling is that nobody in the courtroom seemed to believe she was some hardened criminal. Even the judge openly recognized that these were immature young people making dangerous decisions around firearms. The problem is that when those decisions end in death, courts often feel obligated to ensure the punishment reflects the gravity of the outcome, regardless of how well someone behaves afterward. The judge essentially told her, "You're on the right path, but not enough time has passed yet, and that's where things stand." If she continues complying and reaches the halfway point of probation, the court indicated it may seriously reconsider early termination in the future. This case is also a sobering reminder about firearm safety. One moment of carelessness changed multiple families forever. A split-second decision became a lifetime consequence. If you found this courtroom breakdown insightful, make sure to share your thoughts in the comments. Do you agree with the judge's decision, or do you think her rehabilitation deserved earlier relief? And if you want more deep courtroom analysis, dramatic hearings, and real legal breakdowns, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss the next case.